Okay, we had to go live on YouTube to comply with our Open Meetings Act. Okay, so we are live. Ladies and gentlemen, there are a couple of things that I need to announce today before we begin our proceedings. First, I have an announcement to make about our Texas Eviction Diversion Program. This is some language that I'm required to read out, so bear with me as I read this all out. And this is related to the TEDP program. The Texas Eviction Diversion Program helps Texas tenants stay in their homes and provides landlords an alternative to eviction. The TEDP may provide up to 6 months of rental assistance for eligible tenants who are behind on their rent due to the COVID-19 pandemic and have been sued for eviction. Both the tenant and the landlord must agree to participate in the programs. So I need both parties to agree in order to refer you out. This is a temporary program which is brought to you by the Supreme Court of Texas, Office of Court Administration, and the Texas Department of Housing and Community Affairs. Assistance can be used to pay for the full contracted rent up to 5 months and 1 month moving forward for a total of 6 months. Under the TEDP program, lump sum payments are provided to landlords for rental arrears in exchange for allowing tenants to remain in their homes and forgiving late fees. Diverted cases will be dismissed and made confidential from public disclosure. And so the way this process works is that you just advise me, hello, Judge, hey, I want to participate in the program, and then we will refer you over to the Fort Worth Neighborhood Office. That office is administering the Texas Eviction Diversion Program, and you will go through the process of qualifying for the program, et cetera. The pause button is hit on the case for about 60 days. If any party wishes to opt out, you may motion the court to reinstate the case, and it'll be heard so landlords are not out of their filing fee. Also, a couple of other announcements. If any party has submitted or if any tenant has submitted a CDC contest declaration, plaintiffs are certainly welcome to contest that. And so just let me know. It won't be on today's docket. We'll set that up on a separate docket, and you can contest the declaration. All right, and then the final announcement is this. I did speak with the Fort Worth Neighborhood Office yesterday. They did advise that there is probably about $90,000 left in federal CARES dollars that are available to tenants here in Fort Worth. Also, there's additional monies in the Texas Eviction Diversion Program that I just mentioned. And also there's a separate program called the Fort Worth Community Action Partners. That's a city program, and individuals are able to qualify for rental assistance in addition to food and I believe some utility assistance as well. So a lot of information that I just gave out, and if I need to repeat any of that, I'm happy to do so. But obviously, just please let me know if you wish to participate in the program. We will get all of your contact information and then refer you over to the Fort Worth Neighborhood Office. They will handle all the specifics with getting you set up with the program. Okay, for today's docket, today is March the 10th. The last day a tenant may appeal will be on the 16th day of March, and then the first day landlords may purchase writs of possession will be on the 17th. I will hear all uncontested cases first, and then we have a number of contested cases. So I'm asking all of you to be patient. We will get through this as quickly as we can. All right, first uncontested case, I have Ruben Maldonado versus Trammell v. Morgan. Ruben, if I could ask you to unmute, and then is Trammell v. Morgan here? No? Okay, Mr. Maldonado, you may begin.
I'm sorry?
You may begin with.
Oh.
Yeah, tell me the who, what, when, where, and why.
Well, let me, well, my English is not very, very good. I hope you're going to be able to understand me.
No te preocupes, si gustan, háblame en español, está bien.
Okay. El señor Rameo y yo hicimos nomás un contrato verbal de arrendamiento por 6 meses. Este señor estuvo de acuerdo porque le dije, te voy a poner en un probation para saber qué tipo de persona eres y entonces ya pasando los 6 meses podemos hacer un contrato legal de arrendamiento. Correcto. Sus primeros 3 meses me pagó muy bien la renta. En noviembre, perdón.
Está bien, ok.
En noviembre ya no pudo pagarme porque dijo que se tuvo que salir de su trabajo porque lo querían hacer trabajar más y menos dinero, que si iba a ir a trabajar con su papá, pero no se fue a trabajar con su papá. Total, el mes de noviembre de la renta me lo pagó en diciembre 15, diciembre me lo pagó en enero algo, después ya no me pagó. Y él tengo un papel que me firmó que decía que si él no me pagaba para el 28 de enero, él desalojaba el apartamento al día 1 de febrero, pero él pues no hizo bueno ese papel.
Yo sé. Y Quinta, mira, una pregunta. ¿Cuánto es la renta por mes?
550.
¿Y cuánto debo en total?
En total, sin contar marzo, ¿verdad? No,
A hoy, ¿ok? A las 10 de marzo.
ok, sería en total.
Con sin late fees, no más.
No, late fee, serían 1,632 de renta y serían, porque él no me ha pagado la luz tampoco, el bill está en mi nombre y él lo paga.
Sí, y yo sé, pero la ley dice no más renta no más.
Ok, 1,632.
¿Otra vez?
$1,632.
Ok. Y ya miró su noticia para salir, su aviso. En
Sí,
inglés se llama Notice to Vacate. Y una pregunta, ¿el rentero se dio una noticia, se llama CDC Declaration en inglés? No, ok. Entonces la decisión de la corte es en su favor.
Hotel, The Hook.
Por posesión de la casa, la has to rent 1632 con todo caso de corte. El proceso del guiante es eso. El rentero tiene 6 días para parar ese caso, si gustan, o hacer un nuevo acuerdo contigo. Si algo no, ella no hacer con usted, usted tiene el derecho para regresar a la corte en una semana para comprar la otra orden, se llama writ of possession. Y permite a los alguaciles mover el rentero conversible. ¿Tienes preguntas?
No, bueno, entonces el caso está a mi favor, pero ¿cómo el rentero se va a dar cuenta que ustedes dieron el caso a mi favor? I know that I win this case, right?
Sí, sí.
And like you say at the beginning, he got like 6 more days to appeal for something, and then by the 7th day he will have to leave the house.
No.
Right?
Regresar a la corte. Well, that's what she has to do. Pero primero, regresar a la corte para comprar la otra orden, se llama writ of possession. Con ese orden, los alguaciles pueden mover el rentero conversible si es necesario.
Oh, ok. Entonces,
okay, that's the process.
Yo puedo ir a hablar con él porque no he hablado yo con él desde que empezamos este legal process. I haven't talked to him.
No. Y no te preocupes. No habla con él para nada. Nomás espera tu semana.
Ok. Porque no quisiera decirlo, pero mete mucha gente que no me gusta ahí en la casa. Entran y salen carros.
Sí, yo sé. ¿Algo más?
Es todo, señor. Muchas gracias. Muy amable.
De nada, que te vaya bien y ten un buen día.
Gracias, igualmente.
All right, bye-bye.
Bye.
Okay, next case is Handfork Holdings versus Cassandra Vela. Is the agent here for Handfork Holdings? Wave your hand so I can see you. Oh, there you go. I'm sorry, it's like Hollywood Squares. I'm trying
I have to unmute. I was trying to wave while I was trying to push the unmute.
Okay, you may begin.
Okay, for Miss Cassandra, she entered her lease agreement on November 29, 2020 at a 12-month lease for $1,803 is the rent amount. She was delinquent February. The full amount proration for March is $581.63. Total balance is going to be $2,384.63. She did get a written notice hand delivered to her on November 10th. I'm sorry, February, got all these months. February 10th, 2021. She owes the total balance of $2,384.63.
And if you don't mind, give me the rent again per month.
Yes, it's $1,803, $1,803.
My goodness. Okay. All right. And then finally, did they tender a CDC declaration?
Not at this time.
Very good. Judgment by default for possession, past due rent in the amount of $2,384.63 plus all costs of court. And then you know the drill. Your writ date is the 17th day of March.
17th.
Do you have any others with us today?
I have 3 more. I believe 2 of them are online, I think.
Okay, and then
because I have Samson.
are you doing Woodmont?
Yes, I'm doing Woodmont as well.
Okay, Woodmont Apartments versus Kendra Pete and all occupants. Kendra Pete, are you on? Very good. Let's proceed as default. You may continue.
All right, Miss Pete entered her lease agreement on March 1st, 2020, 12-month lease. The rent amount is $1,036 a month. She was delinquent August, September, October, November, December, January, and February. The full balance of the 1036 proration for March is $334.19, which is going to be a total balance of $7,586.19. They did give her a written notice on the inside of her dwelling on January 4th, 2021, which is asking for possession of property, back rent, and court costs.
Very good. I did see the notice to vacate filed with the court. Last question, did the tenant tender a CDC declaration?
Not at this time.
Very good. Judgment by default for possession, past due rent in the amount of $75,8619 plus all cost of court. I will set a bond at 14. And you know the drill moving forward. If you want to just sit back, mute up, and then we'll get with you on the contested here shortly, okay?
Okay.
Very good, thank you. Next case is at owner 16, DBA Providence at Marine Creek versus Elma Torres, Tammy Torres. I believe we have counsel Robert Rodriguez on the line. Counsel, I see you may unmute and you may begin when you're ready.
Yes, Your Honor. This is an eviction for reasons other than non-payment of rent. These tenants have had a pretty long history. We've submitted several documents. One is the lease where we're alleging that they violated paragraph 20 by engaging in conduct that interfered with the comfort of others and engaging in illegal conduct. Essentially what we're looking at here, there have been multiple run-ins with these tenants and with their guests. We've caught some of their guests urinating on in the back walkways of certain buildings. We've had an incident in December where one of the residents' guests ended up getting a fight on the property and also tried to push her way into another resident's unit. And so for those reasons, which are documented throughout all the exhibits that we gave you, our office sent out a notice to vacate on, bear with me, January 11th, 2021. Giving them 4 days to vacate, and they have not done so, and so we're asking for possession at this time.
Very good. I did see your notice to vacate, and then I read through the file yesterday, and I believe everything is in order. Looking for the exhibit.
Notice to vacate's the last page.
All right, judgment by default for possession only. No past due rent, no court cost. My standard residential bond is $500. Do you have anything further, counsel?
I do not.
Very good. You may be excused. Thank you.
Thank you, Judge. Take care.
There we go. Ladies and gentlemen, the remaining cases are contested. I need those of you who are not attorneys to raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the whole truth, nothing but the truth, so help you God? Okay.
Yeah.
Very good. First contested case is Rna Financial LLC versus Daniel Viganova. I believe we have Mr. Abrams on behalf of Rna Financial, and then counsel David Conan available. So if I could get both sides to unmute, and Mr. Abrams, you may begin when you are ready, and I need you to unmute.
Your Honor, if I could pop in just for a second, I don't believe I have a contested case. I may have missed my defendant checking in, but I'm
Okay,
contested
let's
case.
see here. Are you 4,000 Hewlin Asset Management?
Yes, Your Honor.
Okay, all right. I appreciate you raising the red flag there. They wanna
Sure, we
keep
can wait.
it in.
Obviously, we can wait.
No.
till you're ready.
My deal, I like to get those who are not here taken care of. So just sit tight, Mr. Abrams and counsel, and I'll be with you just momentarily. All right, this is 4,000 Hewlin Asset Management versus Jenny Summers. Jenny Summers, are you on the call? Very good. We will proceed as a default. Counsel, you may begin.
Thank you, Your Honor. Patrick Drake on behalf of the plaintiff, 4,000 Hewlin. We instituted this matter enforceable detainer for monetary breaches of an apartment lease contract. Exhibit A to our petition is the lease itself. It's for apartment 307 at 4,000 Hewlin, Fort Worth, Tarrant County, Texas, 76107. Monthly rent for this unit is $1,788 a month. Exhibit B to our petition is notice to vacate that was tendered to the defendant on January 5th, 2021 by affixing it to the interior of the main entrance door. Exhibit C to our petition is another notice to vacate that was tendered to the defendant on February 19th, 2021, delivered that same way. And that exhibit has the photographs of those notices that were posted. Defendant has failed to pay any amount at all for rent for the months of December, January, February, and now March. Prorated rent through today's date, Your Honor, is $5,940.77 through March 10th, 2021. Plaintiff seeking possession of the unit pursuant to section 32 and 6 of the lease. Delinquent rent in the amount of $5,940.77, reasonable attorney's fees and cost of court.
Very good. Do you have amount on the attorney's fees?
Your Honor, I'd say $1,000 would be appropriate in this case to award to the plaintiff should it prevail.
What is your normally rate per hour?
$295 an hour, Your Honor.
Okay, very good. All right, after everything I've heard and reviewed in the file, the notice to vacate, et cetera, and then one quick question. Did they tender a CDC declaration?
They have not, Your Honor.
Very good. Judgment by default for possession, past due rent in the amount of $5,940.77, plus all costs of court. In addition to that, the attorney's fees in the amount of $1,000. Counsel, I believe you know the process moving forward. Do you have any questions of the court?
No, Your Honor, we've got it from here. Appreciate your time. Thank you so much for letting us jump in there.
Hey, not a problem. All right, you may be excused. Thank you. Bye-bye.
Thank you, Your Honor. You too.
All right, now we'll turn our attention to Rna Financial versus David Viganova. Mr. Abrams, you may begin when you are ready.
Okay. The defendant has been occupying the premises since March 1, 2019 until the current date. I have about 6 checks that were returned to me, NSF that he gave me, and that was when he was paying. He's no longer been paying. Presently, there's $14,400 due on the account, and we're seeking possession.
Okay, very good. I didn't, when I looked through this yesterday, I didn't see the notice to vacate. Do you have that?
Yes,
And then
and he says,
also, this must have been filed this morning. It wasn't in yesterday. But I have a plea to the jurisdiction. So I heard all that you said. Let me put you on pause real quick, bounce over to counsel. Counsel, go ahead and present your motion.
Yes, Your Honor. The attached to the motion was to our answer was Exhibit A, which shows the instrument under which the defendant is in possession of the property, and it's a conditional sale agreement. The occupancy of the property has been since 2011. This is the third time we've been to court with this contract. The first time was with under cause number 28324 in 2019, where Mary Sosa was the plaintiff. She was the successor in interest to that contract. Court rightfully acknowledged that there wasn't jurisdiction there and awarded us attorney fees of $1,000. The second time was June 22nd, 2020, under cause number 29620 with this plaintiff and this defendant. And again, this court recognized the lack of jurisdiction. It's a contract for sale, and under the government code 27.031 sub B sub 5, this court is not the proper venue for addressing this particular issue between the parties.
Very good. Mr. Abrams, let me get a response. What's going on here?
two things, Your Honor. Number one, we notified them of a default on the mortgage if they think that that's what it is. And we had a sale of the property back last year. The contract that they allude to is a conditional sales contract that talks about goods purchased, does not talk about real estate. It talks about a UCC filing, which is a personal property filing. If they think it's a purchase of real estate, they have the wrong contract. And needless to say, we were not privy to it. We bought the property from Lucy Sosa and Jaime Sosa a couple of years ago. So we don't feel, based on a conditional sales agreement, that it is a sale of real estate. I don't see any place in here that talks about real estate. I see goods, retained title goods. I see we can come in there and take possession of goods. I see that we can file a financing statement or a UCC. All those are personal property, nothing to do with real estate property.
Counsel, do you have a response?
Yes. As far as the contract, it's clearly a contract for sale of the property in question. The case law, as well as Texas law, is pretty clear, regardless of how you title it. It's, as long as it's the sale of the property that's intended, that's what is affected. And that's exactly what's going on here. It's pretty unambiguous, actually. It's $68,000, 20 years financed at $600 a month. Payment starting June 1st of 2011. In 2031, the property would be released of the lien. This is an action to enforce a lien that's showing up here in this court today. Regarding any other sale, I'm looking at Tarrant County records. I don't see a sale.
Okay, I have a question for Mr. Abrams. Mr. Abrams, you say that there's nothing about real property, just goods, but here on the conditional sale agreement that was provided by counsel, it says the following goods and it lists an address as being the goods.
Yeah, but that.
How is the court, hang on, how is the court supposed to interpret that?
You can interpret it any way you want, but it doesn't talk about real estate. It talks about goods at 5524 Humbert is the way I would interpret it. If they said the following real estate at, then it would be totally different, but goods is personal property.
And then if you look at the bottom paragraph where it says seller, how's the court supposed to interpret that?
Seller shall retain title of goods? Is that what you're talking
Yeah,
about?
yeah.
Again, it says seller shall retain title to goods. Goods is not real estate. Goods is personal property. I have no idea what the contents of that house were. I don't know.
And then when you look at the last paragraph where it says commercial code, mineral rights, it's not included with typically with any sale of real estate. That's always a clause that's included, whether those are assigned or not. How's the court supposed to interpret that?
That's the only thing in here that would indicate that it maybe is real estate, the mineral rights. But when you look up at the first part, it says purchaser agrees to execute financing statements. That's a UCC, that's personal property. Purchaser shall keep goods. That's personal property. Full balance becomes due on default. The only potential item of real estate in this entire contract would be mineral rights. There's no legal description. There's no nothing in a typical real estate contract.
Okay, well, this is what I'm going to do. I'm going to take this case under advisement. I'm going to set it up for another special hearing where we just deal with this exclusively. And at the time of the next trial, I'd like to see some documentation of what has happened with this property prior to the Sosas and I mean, prior to Daniel Viganova or the Sosas and what we have in place here, because I don't think I have a full picture of what's going on. Any questions from either side?
Yes, Your Honor. I would just raise the issue that I would imagine that the plaintiff would be collaterally stopped from raising the issue, contesting the nature of the contract, as we've already done this before, and there was no appeal.
Well, go ahead.
If I remember correctly, you did not hear it last time, Judge. Judge Valdez heard it, and he didn't say anything other than he ruled in favor of defendant. He didn't say why or anything else. He just ruled in favor of defendant. So as it relates to collateral estoppel, I think it's a little far reaching.
Well, I do think Mr. Abrams brings a legitimate point with raising the issue with UCC as respect to some financial transactions. But again, I want to make sure that I devote the applicable time that is necessary for this particular case. So we'll reset this and you will hear from our clerk, Lisette Arizmendi, on a new date. And again, want everyone to bring any and all documentation that you have related to this property and related to your respective clients. Any questions from either side?
Do you want us to send you my NSF checks and everything else that have been presented?
Yeah, if you want to present that to the court, that's fine. Just make sure that we get a copy over to counsel.
Okay.
All right, very good. Thank you. Parties may be excused.
Thank you, Judge.
Mhm. All right, there we go. Okay, next case here is Keith Kidwell versus Maria Delgado. If I could get the agent for Mr. Kidwell to unmute and Mrs. Delgado to unmute, we will begin. Mr. Kidwell, Mr. Agent for Kidwell.
Your Honor, the defendant entered into a lease agreement with Keith Kidwell on April 1st, 2020. It's currently a valid month-to-month lease. The term of the lease was for 12 months at $1,095 per month. The amount of pure lived up back rent is $1,095 for December, $1,095 for January, $1,095 for February, and $360 for March. It comes to a total of $3,645. Proper written notice was delivered certified mail and regular mail on January 8th, 2021. Keith Kidwell is pleading for possession of the property located at 2414 Dundee Avenue and back rent in the amount of $3,645 and court costs.
Very good. Quick question. Did the tenant tender a CDC declaration?
No, Your Honor.
Okay, very good. All right, let me bounce over to Mrs. Delgado. Mrs. Delgado, are you here?
Yes, I am.
Oh, you're on the phone. Okay, no wonder I couldn't see you. Do you agree or disagree that you owe $36.45 in past due rent?
Yes, I do agree.
Very good. Would parties like to participate in the Texas Eviction Diversion Program?
I
No, Your
do.
Honor.
I'm sorry, let me go ahead and start with Mr. Schultz.
No, Your Honor.
Very good. Okay. Mrs. Delgado, is there anything else you wish to share with the court?
It's just been so difficult for me because of the COVID. I mean, I've had family members that have passed away because of it. My child has autoimmune disease, and it's not really easy for me just to get out there and just start to work. You know, I even have my kids here at home doing their schooling from home because I don't want them to bring something to their younger sister. So it's really difficult for me to be able to keep up with all this.
I understand and can certainly empathize with your situation. We too have had family members pass away because of COVID, and staff members, in particular over in the constable's office, who have passed away for this. So we understand this is a deadly virus, and want your wish and desire to keep everyone protected and mitigate the spread of it, and obviously not touch your household. And I will ask you, have you made any effort to contact the Fort Worth office that's administering the CARES dollars or anything to try to get any kind of assistance to pay your landlord?
I have tried with Catholic Charities because I have tried with, I believe it was the CARES program, but he doesn't have, he says he don't have an email to help provide for that. So I'm like, well, I mean, I don't know what else I can do. I've really been trying to see if I can get some help, but it's just, it seems that they don't answer, or they take, hours. It could be hours on the phone, and then eventually I get disconnected and things like that. So I was hoping I can get referred somewhere where they can actually see my name and help me.
Okay. Are you just talking from a phone or from a computer?
No, I'm talking from my phone.
From your phone. Okay. Because we did put in the chat here some resources that you can contact. But I will have Miss Lisette from our office reach out to you to provide you with those phone numbers, and I'll send an email over to the Fort Worth neighborhood office advising that you're going to contact them. But there's one thing that you said I want to visit with plaintiff about having an email to kind of get, I guess, make contact with the other party on this. Mr. Schultz, did you all attempt to work with her on trying to get this rectified?
I've been by there to pick up rent, and I have talked to her at the door, and Keith has talked to her on the phone. So that much I do know.
Okay. But I believe what she's trying to say is that in order for any type of assistance to be dispersed, to be utilized, that I believe that the neighborhood office has to make contact with both sides, and making contact with both sides, either having some type of phone number or email for either of you in order to start that process.
Yes, Your Honor.
Does Mrs. Delgado have that information from you?
As far as Keith's email address?
Either Keith or yours.
I don't know if she has his email address or not, but I can't say.
Well,
okay. Go ahead. Hey, Mrs. Delgado.
I had actually asked him once for the email for the same reason, because I was going to do it online, and he said he didn't have an email. That's what his response was. So I was like, well, what am I gonna do then? How do I apply for these?
Okay, Mr. Schultz, do you have an email that you can provide that would enable her to go through the necessary protocols that's required in order to try to get some assistance? Yes, to help her, but also to help you as well.
Yes, Your Honor.
Okay, now, will you call her, or how will I know that that has been done?
Do you want me to give you the email address right now? I can do that.
I guess if you don't mind, I guess call her after this, because she's, obviously we're live on YouTube and I don't want everybody and their dog emailing you, okay? That's one of the difficult challenges that we work through here. Okay, Mr. Delgado, I have it on his assurance that he's going to contact you. You can still qualify for some rental assistance, whether it's with this Keith Kidwell or if you relocate someplace else, okay?
Okay.
Do you have any questions of me?
No, that is all.
All right. After everything I heard, judgment favor the plaintiff for possession past due rent in the amount of $36.45 and all cost of court. The process moving forward, Mrs. Delgado, is if you disagree with my decision, which is your right, you have 6 days to appeal. If there's no appeal or no new agreement, then the plaintiff will have the right to get rid of possession in a week. And again, I will have Ms. Lissette from our office make contact with you to provide you with the applicable phone numbers for both offices. And Fort Worth Community Action Partners does help out beyond the rental assistance, okay?
Okay,
All right,
thank you.
anything further from either side?
No, Your Honor.
Very good, parties are excused. Thank you.
Thank you.
All right, everyone, bear with me for a second as I make some notes on this file. Next case is Samson Bluff versus Cindy Willis. If I could get Samson Bluff to unmute along with Cindy Willis. And then, Madam Plaintiff, you may begin when you are ready.
Okay. Ms. Willis entered her lease agreement on October 29th, 2020 at a 12-month lease for $976 a month. She became delinquent in December, January, February for the full balance of the $976. We prorated March for $314.83, which is a total balance of $3,242.83. Ms. Willis did get her written notice on January 12th, 2021, posted inside of the dwelling. We're just asking for back rent, court cost, and possession of property.
Very good. And I did see that you all have been doing a great job of giving more than the 30-day notice. And I want you to know that this court truly appreciates that. Did the tenant tender a CDC declaration to you all?
Not at this time that I'm aware of.
Very good. Let me bounce over to Mrs. Willis. If you could unmute. And the question, do you agree or disagree that you owe 3242.83 in past due rent?
I agree.
Is there anything else you wish to share with the court?
Well, when the landlord sent me the email for the Texas Relief Program, I had did it, but it never submitted right. So yesterday we went in her office and she helped me submit it.
Oh, okay. For the Texas Eviction Diversion Program?
Yeah, I think that's the same thing.
Oh, and when you say you went there, you're talking about our plaintiff here, or did you go somewhere else?
No, my landlord is Jamie Stewart's.
Huh. Okay, I just want to make sure that I'm clear. Was it the CDC declaration or was it the Texas Eviction Diversion Program?
It was a program, it says Texas Rental Relief.
Oh, okay, yes, that's another program that's out there. All right, and so I just got notified on that one yesterday.
Yes.
Yeah, the TRR, it's a new program, Texas Rent Relief. So you've applied for that program.
Yes.
Okay, okay. Very good. Madam Plaintiff, do you have anything on any notes or anything?
I haven't received any notes or emails this morning saying anything different. That we have received anything or dismissed anything. So all I know to do is just to move forward with the situation unless you have, information where we'll abate anything. But as far as I know of, I don't have any of that information.
Okay. Yeah, I'm looking to see if there's an abatement clause on this one. Like I said, I just got this information yesterday. All right, well, during the period of the appeal time, just double check, make sure that you visit with the complex and see what they have done in terms of trying to get this case, resolved peacefully. But I will go ahead and grant the judgment, and then hopefully there will be no need for the actual writ, and hopefully this case can be dismissed, assuming she's in the program and that all the arrears is taken care of. All right, any questions from my other side?
No, sir.
No, sir.
After everything I heard, judgment favor the plaintiff for possession past due rent in the amount of $32,42.83 and all cost of court. Mrs. Willis, the process moving forward is you have 6 days to appeal. If there's no appeal and no new agreement, then they will have the right to get a writ of possession in a week to forcibly remove you out. What I've asked of the plaintiff is that she contact the agent, contact the plaintiff, the actual Samson Point or Samson Bluff, and visit with them to see what all was done to help you with the program. And hopefully you qualify for the program. Hopefully the rent is paid and that this case will be dismissed and that there'll be no need for the writ of possession. So I would just ask that during this 6-day period of appeal that you revisit with whomever you talk to, visit with Legal Aid of Northwest Texas if you want to file an appeal, look at the documentation that we submitted with the filing of this court, with all the CARES Act, the CDC declaration, and see which avenue you wish to proceed with, okay?
Yes, sir.
All right, any questions of me?
No, sir.
No.
Okay, so I just want to make sure you're clear, Mrs. Willis. Make sure you visit with the complex, read through all the documentation that we submitted. If you wish to discuss anything with an attorney, Legal Aid of Northwest Texas is always there, okay?
Okay.
All right, very good. Parties may be excused. Thank you.
Thank you.
Next case is Lark Holdings LLC versus Miguel Johnson and Raymond Borjas and Diana. My label cut off. All right, so Lark Holdings, you may begin whenever you are ready.
Okay, good morning, Your Honor. The defendants, Miguel Johnson, Raymond Borjas, and Diana Salazar entered into a lease agreement with Lark Holdings on November 7th of 2019, and it is a month-to-month lease currently. The original term was for 12 months at $1,200 per month, due on the 1st. They are responsible for 100% of the rent. Their current the current amount of rent owed is for May of 2020, $7, for June, $1,200, July, $1,200, August, $1,200, September, $1,200, October, $1,200, November, $1,200, December, $1,200, January, $1,200, February, $1,200, and then the prorated amount for March through today is $387.10. This brings it to a total of $11,194.10. The defendants are in violation of the lease as written on page 2, paragraph 5 regarding rent payments. And regarding default on page 12, paragraph 27, it does state that they lose their right to possession of the premises if they breach the contract. A proper notice to vacate was delivered by USPS on January 12, 2021. And Lark Holdings is requesting splitting for possession of the property located at 2917 Northwest 22nd Street and back rent in the amount of $11,194.10 and court cost.
Very good. Let me ask you this. The tenants tender a CDC declaration?
And so this is my first time to do this. And yesterday I did get an email from them from
Okay.
two of the tenants. Well, I got one email. There's two documents and I assume that's what this is. I've never seen one before. It says a declaration under penalty of perjury for the Centers of Disease Control. So those were emailed to us yesterday for two of the three. And then there's some kind of employer report, but it's not signed or anything.
Okay, well, I've got a bunch of stuff here that was in the file today. It wasn't in there yesterday. Let me just bounce over to the tenants here. Miguel Johnson, I see you on. Did you tender a CDC declaration form to the, you have that with you?
Yes, sir. I have it with me. It came in the packet that they sent with the eviction, I believe.
That's correct. Our court is required to send out the CDC declaration forms along with information for the CARES Act. And so that's always included. And so you have utilized that and you have given that to the landlord. Is that correct? Okay. I don't have a copy here in court. Can you send us one?
Yes.
Okay. I'm going to put, which is easiest for you, fax, email, or hand delivery?
Email.
Okay, I'm going to put my email here in the chat. Send that to me, and that way I can put it in the file. Okay, Madam Plaintiff, they are indicating that they have submitted or about to submit to the court a CDC declaration. This abates the case until the 31st day of March, but you have the right to contest the CDC document. Do you wish to do that?
So can I ask a couple of questions? So as of the 31st, I could resend a notice and then start this process over, or I can contest the CDC.
No, the process moving forward is this. If you contest the CDC declaration, we'll set this up on a new docket. We just deal nothing with CDC contest hearings, and you'll have an opportunity to scrutinize the document, ask any questions related to that. And so this just abates the case. It doesn't dismiss it or cancel it or nothing like that. If we, during the CDC contest, if we find that they are considered a covered person, then the case will obviously be abated until the 31st day of March. Potentially, it could be extended should Congress, the House of Representatives, pass President Biden's COVID relief package. I believe it's on target to pass. I believe there's an extension in that, but I don't know how far that's extended out. Okay.
Okay.
Now, so.
Excuse me, Joe.
Hang on a second. So potentially through the 31st, but it could be extended longer if there's any new provisions by federal law. Any other questions or concerns, Madam Plaintiff?
Yes, because I guess my question is, we were also, because their lease is expired and we're going to have to move forward in a different direction of this property because it's created a financial burden. So we were going to be sending a non-renewal as well. If we do, I guess if I go through the abatement process, am I still allowed to continue moving forward with my normal processes as far as non-renewals and things like that?
Okay. Well, you're asking legal advice. And
Okay.
That's where I have to draw the line and can't answer that question on that. I will refer you over to whom all you utilize to get legal consultation.
But if I do the abatement, I can always withdraw that if I want to not move forward with eviction.
No, you can't withdraw the abatement. What you can withdraw is any problem or any, if you participate in the Texas Eviction Diversion Program. If you both agree to that, obviously there's a 60-day period of abatement to let the paperwork go through to get monies dispersed, etc. If any
Okay.
reason during that point that you wish to opt out, then you could withdraw and motion to reinstate and put this back on the docket. That's not in play here. What we're dealing with is
The
just the
CDC.
CDC declaration.
Okay, so the question is, do I want to move forward with contesting the CDC
That's
declaration?
correct. That's correct.
Okay, I guess that would be yes, if that's the only way to move forward with the eviction process.
Okay. Okay, Mr. Johnson, sorry to cut you off, but you had a question. Go ahead.
Yes, sir. I wanted to tell you that I was left out of water for 3 weeks. I'm still out of water. She refused to fix the water. She said she wasn't fix the water until I leave. The hot water heater was broke. It's broke. It busted. So they came over, and when they came over, they said they told me not to touch anything and not to do anything. So I'm still left without hot water. I have Diana here with cerebral palsy. So we couldn't take a shower for those 3 weeks. We couldn't borrow water for those 3 weeks. She has cerebral palsy. So how is she supposed to do everything she's supposed to do if they left us with no water? And her exact statement was, I don't give a F if you have water or no water.
That
And we
is not
still
an
have no
accurate.
water right now.
Okay, well, obviously what you're telling me is very disturbing. Let me get a response from the plaintiff.
So first of all, we would not even have known their water was off had we not gone to the property, because they've not notified us of any issues. The property's in disrepair due to the wet condition, due to their tenancy. After the storms, because honestly, we thought he had moved out. He sent a text back on December 11th saying he was going to move out January 15th. Then when that date came, he sent another text saying he'd be moving out, but that he feels confident that landlords like myself get relief from the government, which we do not, that he was not new that, but never did he notify us that there was an issue with water. But we were being proactive on some of our properties because I thought, well, maybe he's vacated. And this was 3 days after the snowstorms, or 2 days. It was the Saturday after. So we drove properties to try and determine, we had busted pipes, we have houses flooded that we were trying to file insurance claims on. So we went to the property, one, not knowing if he even still lived there, and did not realize that Diana still lived there, because over the last several months, I've gotten reports that Mr. Borjas has moved out, then he didn't, that Diana had moved out, then she didn't. So really was unaware of who the actual tenants are. We've had a hard time getting communications. Even when I've attempted to call Diana's phone, it says it doesn't, that number wasn't accepting calls. So anyway, they're not reporting service issues, which they're required to do per the lease. It states that they are supposed to do that. The only reason we knew there was an issue with the water is because we went to the property, not because they notified us. They are still obligated to put service requests in writing to us, because we have to have that documented. Mr. Johnson has been a little bit abrasive with us, as if we're going after him. We're not. Like, we're out a lot of money. We're just trying to take care of the property and take care of ourselves. So anyway, until yesterday was the first time he sent an email actually reporting that there was a water issue. It's not just because we were on site, they're responsible.
Okay, let me just say this. I don't know if it's pipes bursted because of the storm, or whether it was cut off intentionally by you all. Whatever the case it is, make sure it gets restored.
Yeah. Well, the water service has been our name.
I'm not done yet. Not done yet. Okay. Then, if they don't have it, please make sure that they have the bottled water that they need to consume, cook, do whatever, because they can't be without water. Wait a minute, not done now. Then, Mr. Johnson, if for some reason that this is not rectified, there is a provision, or there is a recourse for tenants that you may file a landlord-tenant remedy case to remedy the situation here in justice court, and I can hear the merits of that case and render a decision in that respect. Madam Plaintiff, you wanted to say something?
Yeah, the question was, it's my understanding they have water, they just don't have hot water. They have water.
Go ahead and
That's correct,
clarify,
or-
Mr. Johnson. Do you have water or is it just the hot water?
Yeah. The hot water, I have to, if I turn on the water from outside, it floods everywhere
Oh,
in the garage. So I can't use the water. So she's saying that I have cold water, but if I turn it on, everything gets flooded.
and then
Well, I
down.
wasn't
Okay.
aware of that. I
Okay.
wouldn't
All
know
right.
that.
Well, everyone is on notice now. You are aware of what's going on over there. Mr. Johnson is aware of what rights are available to him, what is essentially required of the landlords to make sure that they have the water they needed, particularly when we have someone who's special needs. So are there any final questions from either side?
Yeah, I
Yes,
just,
sir.
Okay, one at a time, Madam Plaintiff.
so just to make sure, so right now it goes through the contesting of the CDC, which I assume I will get some documentation on that process.
You will hear from our court clerk and she will advise you when we're going to set this up on the CDC contest hearing. I suspect it'll be the week after next because I'm out of state next week.
Okay, all right, thank you.
Anything else?
No, I believe that's it.
All right, Mr. Johnson, did you have a final
Yes.
comment? Go ahead.
Yes, sir. I didn't get the email that you said I was going to be sent in the comment section.
The email address is listed in the chat. If you go to your Zoom and you pull up the chat, you can see my email address. If nothing else, just call us and we can give you the email address or fax number. But it's Justice of the Peace Court, Precinct Number 5, downtown Fort Worth, okay?
Yes, sir.
All right, and then also, I want to advise you that when we do the CDC contest hearing, I want to make sure that you have abided by every aspect of that declaration, okay? So when it says that you've reached out to all government assistance, make sure that you have that to report to the court. And I will specifically ask you whom you've contacted, who you spoke with, and what emails you have received from either Tarrant County Cares, Fort Worth Cares, Texas Rent Relief, Fort Worth Community Action Partners. So there's some responsibility with respect to what you need to do to make sure that that you've abided by all aspects. Any questions?
No, sir.
Okay, very good. Parties are excused. You'll hear from our court clerk with respect to the CDC contest hearing. Thank you.
Thank you, Your Honor.
Bye. Okay, thank you, sir. All right, last case is Woodmont Apartments versus Yolanda. I hope I don't pronounce this incorrectly. Is it Sieben? And you're there you are. Can you hear me now?
Yes, sir. It's
Okay.
Saban, but that's close.
Is Saban?
Yes, sir.
Okay, well, my apologies, and I'll make sure I won't make the same mistake twice. Madam Plaintiff, you may begin.
All right. The defendant entered her lease agreement on April 1st, 2020 at a 12-month lease for the rental amount of $1,021. She became delinquent in November, December, January, and February for the full amount of the $1,021, and we prorated March for $329.35, which is a total balance of $4,413.35. She did get a written notice on the inside of her dwelling on January 4th, 2020. We're asking for possession of property, back rent, and court costs.
Very good. And then I actually saw that you tendered 2 notices to vacate, quite honestly, and so I appreciate you doing the both there. Let me ask you this, did the tenant submit a CDC declaration?
Not that I'm aware of at this time.
Okay, very good. Let me bounce over to the respondent in this case, Madam Tenant. You may, let me ask you a question here. Do you agree or disagree that you owe $4,435 in past due rent?
I definitely do agree. And COVID.
Okay, is there anything else you wish to share with me? I think your screen froze up, ma'am.
I'm sorry. Okay, I'm sorry. I'm in the car because it's the best. But I do agree. It's not.
Okay, and I'm getting about, I'm getting every other word and every other word is garbled. So I'm wondering if we should just revert to an old fashioned telephonic hearing here. Let me make sure that I've got your, what is your phone? Well, I don't know if you're able to put in the chat your phone number. Mrs. Sabon. She's frozen up. Madam Plaintiff, do you have her phone number?
I do not.
Okay. Well, Ms. Sabon, if you can, just try to log out and log back on. Sometimes that'll work to unfreeze, but all I have is just a freeze frame of you. Okay, she's heard that. All right, go ahead and mute back up, Madam Plaintiff. We'll wait for her to come back on. But there's somebody else on, and I don't have any more files, and I just want to find out what's going on here.
It looks like this Cassandra, that was we got a default judgment on that. And that was for Hand Folks Holding. That's who, I believe that's who that is.
Oh, is that?
I'm looking at the name.
Okay, Mrs. Cassandra Vella, if you could unmute.
Hi.
Hello, all right. So was your docket at 9:30 or 10:30?
11.
I'm sorry, 11. And so were you on the call when I announced earlier?
Yes, but I don't understand it because I have never done this before, so I don't know what you meant with default.
Well, default means is that whenever I announce the case, you did not answer.
Oh, I'm sorry.
Were you here when I made
Yes.
the call? Okay.
Yes.
All right. I will ask my bailiff to go get that file, and that way I can rehear this, and then we can go through. It's Madam Plaintiff. Tell me the name of the plaintiff again.
Her name, it's for.
It's for you.
Hand Forks Holdings.
Handfort Holdings versus Cassandra Vella.
Yeah, the
Okay.
case number is 30179.
Okay, he's going to go and retrieve that file, and then I'll hear that one here shortly. Okay, Mr. Savon, have we got you back? Or did you freeze up again? Technology, you gotta love it. Okay, you have frozen up again. I tell you what, I want you to, I don't know if you can write this. Oh, there you are. There you are. We've got you now.
Yes, sir.
All right, so I can't remember where we last left off, but I know you agreed with the amount that was owed. Was there anything else that you wish to share with me? Go ahead.
I sent over via email to the email address that was on the form. The form I signed showing that in October, this was an emergency for me. I lost my job due to COVID, everything. And it said that literally, I want to pay them, but if I'm kicked out, me and my kids will be homeless. I don't have anywhere to go, but I've been working. I've been applying for places, not just jobs, but for assistance, but I was working on being a teacher. And the district in Grand Prairie, at first it was okay because I could be home with the kids. And then they made it where we had to go back in person. Well, when we went back in person, it was through a grad program that I even had the job. So the payment was like a stipend. We didn't know that COVID would alter the stipend money and when it was coming. The complex here has been with me since I got out of a domestic violence shelter. Like, I love my apartment complex. I love the staff. Like, they've always worked with me. They know that I've worked with Catholic Charities to help me. Like, I haven't gotten to this point where I was on my feet and it just dropped.
Let me go ahead and I appreciate everything that you said, and I admire your work as a teacher. Believe me, I wouldn't be where I'm at without great teachers. And so thank you for that. But one thing that you said that was critically important, you said that you emailed me the form. What form are you talking about? So
the program with Catholic Charities, they had me to sign, I believe it's the declaration that stated that.
Okay, I'm looking through my email, pardon me, and let me see if I've got anything.
Okay.
Would it be coming from, what is your email address?
My first name
Uh-huh.
minus the last letter, yolandion@gmail.com. I think I put my name and I put the case number attached to it. One was a forward for my, there's like my counselor with Catholic Charities, Mr. Andrew Dickinson. It would have forwarded over from him that form that they presented to me, showing that the hardship. And just knowing I was behind, I was very honest with them. They're working on helping me. It's just the wait process. I've recently applied for unemployment. I'm still waiting to hear something. I've applied with the CARES Act. I'm waiting to hear something. I've looked into other resources on where to move because my lease will be up, and I don't know what to do.
Okay.
I don't know what to do.
I don't have the email as of yet, but you're telling me that you've signed a CDC declaration.
Yes, sir. And I sent the email yesterday. Yes, sir.
Did the plaintiff get it?
I believe so. It was sent directly from Catholic Charities over to them. It was forwarded over to them from Catholic Charities after I signed it.
You have to sign the declaration.
Yes, sir. Yes, sir. They printed it out. They scanned it while I was there, Mr. Andrew Dickinson,
okay.
and they sent it over on my behalf.
Okay. Well, you're under oath. You're telling me you've done that, so I'm going to go ahead and hit the pause button on this. But I want to make sure that we get that here in court. So please make sure that you have them send that to us. If you have the hard copy on your own accord, email it to us, fax it to us, bring it by. Make sure your landlord has a copy. Okay.
Yes, sir. And I sent it to the JP5 court.
Okay. Then I will ask, I'll go up front. That goes to the general. That's not, I thought it was my personal email. And so that's why I thought it was in there. Okay. So I will note here that a CDC declaration has been filed. And then I will ask, Madam Plaintiff, do you wish to contest?
Nope, we're gonna just let it be for the abatement for the 60 days, and we'll just go from there.
Bless you. Bless you. Thank you, ma'am. Thank you. Thank you.
Okay, Madam Defendant, Respondent, you have filed that. I'll get it. I'll put it in the file. It abates the case until the 31st day of March. Potentially, it could be abated longer, pending federal legislation that could pass. Do you have any questions of me?
No, sir.
Good luck to the both of you, but to Mrs. Savon, good luck to you in your teaching career. Okay.
Thank you, sir. Thank you.
Always consider Fort Worth as a place to lend your service. We need your talents. Okay.
Bless you. Bless you. Thank you.
All right. Take care. Bye-bye.
Bye-bye.
Okay, I had this case earlier, but Madam Respondent Vela was on, but for whatever reason, muted or what, I didn't hear. So I'm going to scratch everything out and we're going to start anew. So in the matter of Handfork Holdings versus Cassandra Vela, Handfork, you may begin.
All right, the defendant entered her lease agreement on November 29, 2020 at a 12-month lease for $1,803 a month. She became delinquent in February for the full balance, and now for March is prorated $581.63, which is a total balance of $2,384.63. She did get a written notice hand delivered to her on February 10th, 2021. We're asking for possession of property, back rent of $2,384.63 and court costs.
Okay, I asked this earlier. I know your response, but just for the sake of, because she's now with us, did she tender a CDC declaration?
Not that I am aware of.
Very good. Okay. Mrs. Vela, you've heard the plaintiff. Do you agree or disagree that you owe $2384.63 in past due rent?
Agree.
Is there anything else you wish to share with me?
Yes. So the lease apartment, it was with me and my ex-boyfriend. For domestic abuse, he left. He signed his name off the lease and everything. And that's one of the reasons why I was late for the rent, because we he was on the list too, so we were gonna like we were sharing the rent. And now it's just me by myself. I have no vehicle. So I work on Baylor, so I have to Uber myself every day back and forth. And I called the 211 number and I talked to the Catholic Church charity, the Salvation Army, the CARES plan, and everybody else that I called, they don't have any funds. So it's just like I work, like I said, I'm a PCT on Baylor, so I do have a job and I'm able to pay. Like I have the money for the rent, but it was either pay the whole rent or find my way back and forth for work. And I don't know if there may be like I can do some type of like payment arrangement because I don't have nowhere to go. It's just me. I have nowhere else to go.
I understand and I appreciate this.
And I have a record where it shows that my ex, he was a violent person. So it was like a matter of death or life. He needed to be out completely out the lease.
I understand, and there is a provision in the law that permits the victims to essentially breach the lease without consequence when there's a situation of domestic violence. And it looks like he's out of the picture, and so but you've continued to stay there, correct?
Yeah.
Okay.
Because I have nowhere to go.
And I understand. Now I want to ask you this. Have you contacted the Fort Worth neighborhood office to apply for dollars through the CARES Act or to the Fort Worth Community Action Partners?
Yes, and they said that they have no funds.
Well, that's not quite true. And I will let you know that I spoke with them directly yesterday, and they told me that there's about $90,000 left in the federal CARES pot, and that there's additional monies through the Texas Eviction Diversion Program. I don't know if that'll be applicable here, but also through the Fort Worth Community Action Partners. I do know that Catholic Charities, they've been bombarded and they've essentially depleted their funds, but there's other programs out there that you can apply for in order to try to qualify and get some assistance to help pay down this rent. In addition, they'll give you, Fort Worth CAP will provide some utility and food and clothing if need be. Okay.
Okay.
All right.
Yeah, because I don't know any of those. Like, one of my coworkers said, well, I will just call the 211 number, and I call and they give me like 4 or 5 numbers. Like one of them like didn't answer, and the other one, well, we have no phones. So I was like, well, what else can I do?
Okay, well, I think in the chat here, my clerk did put in information for the rental relief, and it's there with the eviction diversion program. And then let me just, and then also with the Fort Worth CAP program. So it's in the chat. Are you able to pull that up?
Yeah, I'm looking at it right now.
Okay, so give them a call now and try to do that because they can help you with some funding. Now, there's not much I can do at this point other than to grant them the eviction because they pled for it. You've acknowledged that you've owed it. However, during the 6-day period of appeal, hopefully you can get something rectified, get some assistance, and that there'll be no need for the writ of possession. All right?
Okay.
Do you understand that? Do you know what the writ of possession is?
So meaning I have to like leave in 6 days?
That's correct. What happens is the writ of possession is another order that I sign, which is in a week. The consuls by statute will give you a red tag on, place a red tag on your door, giving you the final 24 hours to vacate. And then that's when the complex will show up with people to actually move you out. But during that 6-day period of appeal, 7, that's when you contact the neighborhood office, see what kind of monies can be allocated to you to pay down this debt with the complex, okay?
Okay.
If you get it all rectified, then there'll be no need for the writ of possession. I don't want to speak for them, but I'm sure the last thing that they want to do is have to actually go through the process of a writ of possession on that property.
Okay.
Okay. Are there any questions or concerns?
No, I guess no.
Okay. All right. Well, very good. Thank you so much. Parties may be excused.